Our perception of money is changing rapidly, and banks are at the center of all of it. From how we access it, to how we buy, to how we trust that that money will be there when we need it. I'm Kiah Haslett, the creator of FinTech Takes Banking. Here on Bank Nerd Corner, I talk with bankers, economists, academics, and more about the complex dynamics shaping the financial services landscape. This week on Bank Nerd Corner, I'm joined by Andrew Grant, a regulatory attorney at the Runway Group, to discuss the 1978 Supreme Court case Marquette National Bank of Minneapolis versus First of Omaha Service Corp. This seminal banking case addressed the important question of where a loan is made and why that matters. The decision and a subsequent act of Congress made interest rate exportation a mostly settled question for decades. But as Andrew and I discuss, a recent court case throws a new wrench into this established area of law and finance. Banks worldwide use Tactile's AI decision platform to power their credit, fraud, and compliance workflows, and adapt them in weeks, not months. Built for banking, Tactile's platform is transparent, audit-ready, and made to test and optimize decisions continuously. Learn more at tactile.com. Hey, Andrew, thanks so much for joining me today.
Hey, Kiah, it's great to join you. It's when I've always loved this podcast. It's really exciting to be a part of it.
Yeah, well, welcome to the Bank Nerd community with, I think, what's going to be a real banger of an episode and a case. And kind of strangely, when we talked about this at Money 2020, it was just, it was more like, hey, what case is very important to you in your job as a regulatory attorney? But now this case is really, really topical. Do you want to comment on the Colorado 10th Circuit decision and, as a preview to today's case?
Yeah, so obviously, we've got a dual banking system. We very intentionally have a dual banking system. And what rates you can charge and who you can charge them to has been an exceedingly important question. And now you've got a risk so basically Colorado opted out of the ability of states to export rates into their state.
Yeah.
That was the question of can out-of-state banks, state charter banks, come into Colorado and charge a higher rate of interest?
Yeah.
Colorado's like, you shouldn't be able to do this. The 10th Circuit agreed. Will the Supreme Court hear this case? I'm skeptical. And so this opens up an avenue where we had this desire to kind of put state and national chartered banks on equal playing fields. And right now, that may not be the case. And it opens the case for more states to potentially pursue this. So this decision in the late 70s may be very integral for what banks are thinking about as they move forward for what should we do if more states follow this.
Yeah, well, It's crazy, literally, that we're here today to talk about the 1978 Supreme Court case, Marquette National Bank of Minneapolis versus First of Omaha Service Corp. And everything you're telling me, I'm going to be future applying to the questions that the Colorado 10th Circuit decision talked about. But let's go back to 1970. What was consumer credit in banking like in the 1970s that leads to this case?
So at that time, there wasn't a ton of interstate banking and credit cards were still fairly new. And so usury has always been, I'm going to go back even further.
Okay.
Usury has basically been this abhorred concept almost since time immemorial. It's reviled in the Bible. Dante put them in the seventh circle, usurers in the seventh circle of hell. Like Shylock and Pound of Flesh.
Yeah.
It's always been this kind of moral issue. And states themselves, had very strict usury laws in the 1970s. You didn't really have these states that had uncapped usury laws. And you combine that with now you've got the growth of credit cards. Credit cards didn't start until 1950, really, with Diners Club.
Right.
But it wasn't until 56 or 58 or something like that with, who was it, Bank of America, did the Fresno drop, 60,000 cars. Yep. And so that was kind of the first mass general credit card. And so Visa and MasterCard didn't exist at this point yet, though the precursor to MasterCard was a a ancillary party in this case for both entities. And so you still have this nascent but growing credit card market without a lot of interstate extensions of credit going on because you had these very limited usury caps. And we're also starting to see a high rate of inflation going, which matters for various reasons that I think we'll talk about in a little bit. So that's kind of the state of play in the 70s that kind of led up to this. You had usury, states took it very seriously.
Yeah.
But you had this growing tension of interstate extensions of credit.
Yeah, and I think the role that the credit card plays here is pretty important too, because it was this idea that you could sell a credit product to consumers in other states, right? Bank of America does the Fresno drop, and Bank of America is, I believe, in California at the time. But the mail goes to states beyond the state that you are operating. And so now these banks can reach different customers, right?
Yep, exactly. And so that's, that was a key component of this case was, one bank are coming into another bank's
territory. Yeah, it's almost like a turf war.
And basically, that's 100% what this is. So, it's a pretty unusual case in that regard. So tell me about Marquette, National Bank of Minneapolis, and First of Omaha Service Corp. Who are the named parties in this lawsuit? So this is functionally one bank suing another bank.
Okay.
And by extension, one state suing another state. So you had Marquette National Bank of Minneapolis, so Minnesota. In a national bank, it's chartered in Minnesota.
Sure.
Versus First of Omaha Servicing Corporation. So originally, there was National Bank of Omaha was a party to the case. Mm-hmm. They were removed from the case to try and do some jurisdictional issues to get the case out of federal court. They're like, okay, we want to get that out and put it into state court. So they dropped it and they left it against the Servicing Corporation. And at that time, the Servicing Corporation, their role was to, hey, we're going to go into Minnesota and we're going to try and get merchants to accept our card, as well as get banks to accept the drafts for deposit from those merchants. So they weren't signing up they weren't signing up consumers. They weren't signing up you. I mean, they weren't signing up you, Kiah, or signing up me, Andrew. Mm-hmm. That was being done through the mail.
Yeah.
But so they left in First of Omaha Servicing Corporation. And so those are the kind of two parties in the case. But even though a bank isn't really a party, it is effectively bank versus bank and state versus state. Yeah.
So tell me about the two states behind each bank, right? What does Minnesota have against Nebraska?
So what Minnesota has against Nebraska is they have a different rate of interest.
Okay.
They have a different rate of usury that they allow. And so basically, Minnesota had a 12% rate of usury for credit cards.
Okay.
Nebraska had 18%.
Sure.
To make up for that delta, Minnesota allowed for, what's effectively an annual fee or something like that, or a monthly. So it's you could charge $10, $15 or something as well. So, and they're all on what's called the Bank America card plan, which is the precursor to Visa. So this is, the quote unquote precursor to the Visa network. They're all on the same card plan. And you have got Omaha Bank coming into Minnesota and saying, free cards. Our cards are free. You don't have to pay this $10 fee that this Minnesota card is charging you. And Minnesota and, Marquette were like, this is harming us. We are losing business, because these other banks from out of state are able to come into our state and say, you can get a free credit card, even though, the APR is higher. I'm assuming back then consumers still frequently now overestimate their ability to make payments on time and all that stuff, and don't always necessarily understand how interest is calculated, assessed, but they understand free versus $10.
Yeah.
And so there's this allegation that, Marquette is losing customers to this. And corollary to losing customers is we also think ours is more fair.
Yeah.
We have a lower rate of interest. You are charging a higher rate of interest than we allow.
Okay.
You should not be able to do this.
Okay. All right. So we've got the two banks, we've got the two states. Yep. What is the central question of this case or the arguments that the parties made? And why did they make those arguments?
So basically, the central issue in this case is, so you've got the National Bank Act.
Yes.
And the National Bank Act has language that basically states, any association you can take, you can receive, you can charge interest at a rate allowed by the laws of the state where the bank is located. So that was the central issue of this case is, what does it mean to be located for a national bank? That had not yet been litigated before. And Minnesota's position was, well, located means you are coming into our state. Doesn't matter if you have a branch. You're coming into our state. You're advertising to our customers. Our customers are transacting in Minnesota. And therefore, you should be deemed located for purposes of the National Bank Act and what rate of interest you can charge by these factors, by your coming in here, not by the factor of, and this is what the Service Corp kind of put forward, location is where you're chartered, like where you put on your chartering certificate. We are chartered in Nebraska. And so those were kind of the central or the main argument is just, how do you define what located means?
Yeah. When
you're trying to determine what rate of interest you can charge.
And I guess this question, again, hadn't been really asked because banks really hadn't tried to make loans in other states, right? Or this was maybe the first time we were having these differences were really mattering?
Yeah, so interstate credit extensions, they were a thing. It's part of why, this idea of forming, and the court goes into it, why we had this national bank concept and why it was important. But from a consumer perspective, it was still at its fairly nascent growth of me being in one state and getting credit from another state. It's part, the court goes into some level of detail of there's the National Bank Act implicitly permits this, where there's no, Minnesota could point to nothing that says, if I'm a resident of Minnesota and I go to Nebraska for whatever reason, and I want a loan from a Nebraska bank, of course I'm going to be charged Nebraska bank's interest rates. There's nothing remotely in the National Bank Act or the history of the National Bank Act that would read it any other way. And to your point about technology with mail, it was that concept of hey, just because there's a different mechanism as opposed to crossing a state line, that doesn't change the basic underlying premise of where a bank is located. All
right. Yeah, I think you're kind of gesturing, but what did this Marquette decision establish when it comes to making a credit decision?
So basically, the court was unanimous here.
Nice.
And so it was kind of two things. One, they said a bank is located, and they were very clear here and very no wiggle room. A bank is located in the state in which it's chartered. The court stated, a bank could not be deprived of that location because it extends credit to residents of another state, especially because it assesses the finance charges in its home state. Payments are received there, and it issues the cards from there. And like I said, in doing this, it looked at the history of the National Bank Act, and found that there's no other interpretation we could plausibly come up with. And to kind of the consumer protection point, the state was well, if you do this, you're kind of going back to, again, that really basic point at the outset of usually it's kind of been a word since time immemorial. It's you are preventing us, Supreme Court, if you take this approach, from helping to protect our consumers. And the Supreme Court is sure, we are.
Yeah.
But that's not our purview. That's go to Congress.
Right,
if this is an issue, this is something Congress should take up. This is implicit in the National Bank Act. This is why they established in part the National Bank Act. If you have a problem with this, it's not our job to overrule that.
So I think like one thing kind of in this case is that both of the parties are national banks, correct? Like First National Bank of Omaha and Marquette National Bank of Minneapolis. And so we're not actually even arguing about whether these banks can make loans across the nation, right? Like they're both subject to this law that allows them to do that. But I think one of the impacts of this case is that there's like a follow-on, right? Because this ruling actually only probably held for the banks that were nationally chartered, right?
Correct.
So what happens? With this ruling?
So a few things. So like this is a very interesting time in U.S. financial history. We had rapid inflation shortly thereafter. And so, there's one immediate actual effect from the case itself. And then there's a kind of corollary you mentioned of like, this is a state charter or federal charter versus state. So kind of as noted, like credit cards were still kind of new.
Right.
Like they were still really becoming a thing. And Citibank was losing a ton of money on its credit cards. Like estimates were like it lost about $1 billion in its credit card program. And they were based in New York.
Okay.
And so this was 1978, and I was 1 year old at the time, so my interest in consumer finance had not yet really grown. Everything I've read said contemporaneously this case didn't really cause a big ripple at the time.
Yeah, right.
But 2 years later, Citibank is like, hey, we're losing a bunch of money by being in New York in its limited interest rate environment. South Dakota, you are changing your usury laws. And there's a weird idiosyncrasy at the time that if you were an established bank, you had to get an invitation from the legislature to come to a new state.
Okay.
So Citibank was calling. Citibank was calling the governor of South Dakota. Like he got like 5 calls in a day from different people being like, we need to get this legislation moving forward. You need to invite us. Mm. And they did. And Citibank moved to South Dakota.
Wait, because South Dakota changed their usury law?
Yeah. Okay. South Dakota changed its usury law. It was uncapped. And now because of Marquette, it gave that sort of protection. It gave that confidence. We can go into South Dakota with our credit card program now. And we can send credit cards wherever we want to.
Right, because we'll be making the loans in the state. Yeah.
And people will pay the interest rate that they have to pay because South Dakota allows them.
Okay.
And so Delaware did the same thing a year later. And so that's why you see all of these national banks now in these jurisdictions. Like, why is Citi one of the largest banks in the world in South Dakota? Why are they in Delaware? Why are they in like the money center capital like New York?
Yeah.
Like, well, this is the reason. It's because of interest rate exportation. And then for state chartered banks, like same thing. Or sorry, not quite same thing. Like they didn't have a law.
Yeah, it was the opposite.
And so they're like, what do we do here? Combined with, like, they're getting hammered with inflation. So you've got states that have like a 12% interest rate, but the borrowing rate is 20% or something like that. So it's like, how can we meaningfully extend credit to people when it costs us more to borrow? And so part of Section 85 of the National Bank Act, in addition to interest rate exportation, it also allows you to charge more than your home state interest rate in certain
that's handy.
circumstances. So they adopted something called, Congress passed in 1980, the Depository Institution Deregulation and Monetary Control Act. I call it DIDMCA. Other people, I think, call it different things. Colorado case called it DITA or DITA or something like that. Some case also just called it MCA recently, which confused me. I think of it merchant cash advances when I hear that.
Yeah. You can't just change acronyms like that in the financial services space because you might be talking about something else.
Exactly. I'm like, but and so as part of that, they modeled that section to allow interest rate exportation off of Section 85. And so it now gave state banks, this interest rate exportation that they didn't, necessarily have before.
Sure.
And this language has not been challenged in courts by the Supreme Court. Like the most persuasive is like a circuit court in like 1992 or something like that.
Okay.
But otherwise, it's through FDIC opinion letters, general counsel opinion letters, basically stating where Congress uses the same language. In one statute, it's meant to mean the same thing in a different one.
Right.
And kind of even going back to what the Marquette court said about, hey, if you have a problem with usury protection, take it up with Congress.
Yeah.
Congress actually doubled down on it
I
and
know.
said, too bad. Like, not only are we not going to protect this usury of states, we're actually going to allow state chartered banks, again, because we want to have this level of parity. We want to allow them to do the same thing. And so because bank parity is important. This is a goal of, the U.S. government.
Yeah.
And so the one interesting thing that DIDMCA did was it gave an opt-out.
Okay.
Which is what we were kind of discussing at the outset with Colorado. It's like, hey, if you don't want to if you don't want to participate in DIDMCA, you can opt out. What does opting out mean? That's the issue du jour right now.
Yeah, it's funny because I think, you started off by talking about the dual banking system, but we also have federalism, which is the dual banking system, but for politics and states and the national government. And it's like, it is interesting that in order to create this parity for one industry, Congress was almost like kind of playing with its authority over states, right? And the idea that the state can determine its usury limit or Congress can somehow usurp that. And how do you how do you walk that line without kind of completely getting rid of this idea of federalism, at least in this area? And I guess it's in this opt-out. And it sounds like, maybe not that many states took the government up on that offer in the 1980s, right?
Yeah. So right now, there's 2 states in Puerto Rico. There's Colorado and Iowa.
Okay.
And then Puerto Rico have opted out. At the time, 6 states opted out, including Colorado.
Sure.
Colorado opted out, opted back in, and then opted back out again. And so, I think we'll talk a little bit more about kind of the future impacts of this stuff.
Yeah.
But at that time, not a lot of states opted out of it. Most of them that did opted back in.
Sure.
And so kind of one of my thesis for this whole conversation is what you just mentioned, federalism. It very much is this idea of who has authority to regulate interest and how, if you're going to say that banks can export, what avenues are states going to push back on? How are they going to find different approaches to doing this? Because again, it's this very, moral might not be the quite right word per se in the banking industry.
Sure.
But it is a very charged concept. It is a very passionate concept for protection.
Yeah.
And something that people have looked to regulate forever.
For sure. And we cover the spread industry. And so kind of usury or interest is just kind of a fact of life. It's the cost of money. But obviously we're talking about it kind of from this financial lens and not really from the consumer protection lens or the idea that there's this idea of fairness or how much or profit or, who gets charged what rates for what products. And, I obviously a state legislature has to balance a lot of those interests. And also, you kind of want, you don't want people to feel like they're getting ripped off. And so if something just kind of seems too expensive, a price cap might be kind of that seems like it might be a reasonable solution if you were a legislator that rather than, maybe other types of products or services, right?
Yeah. Obviously we had the Durbin Amendment for card interchange.
Yeah.
And there's been talk, the last half decade, maybe not quite that long, about, some sort of credit card interest rate bill.
Yeah.
That for a brief period of time looked like it may have been gaining traction under the Biden administration.
Yeah.
I'm not sure if that's currently an issue that Congress is going to pick up again. But there's been talk for a while about, hey, we think, and it did get bipartisan support. That was the whole point. it surprisingly was getting some bipartisan support. So yeah, this idea of, again, how you charge customers, what you charge customers, what should be permissible, is very much an area of concern for many people across, political aisles here.
Well, before we leave fully the 1970s and 80s and this court case and the legislation in response, are there any issues that aren't settled from this case that we need to keep in mind as we move through time?
Effectively, no.
Okay, so they actually kind of solved it in this in that time period, 1978 and then 1980.
More got into the mid 90s.
Yeah. Okay. For that. Fair.
So like the big outstanding question, there were a few ancillary things, like what can subsidiaries do, stuff like that.
Mm-hmm.
Dodd-Frank kind of nullified that, but it was actually, what is interest?
Yeah.
Most people think if you're a non-banking, I'd be like, okay, interest is some type of rate applied to a balance I have on a loan.
Mm-hmm.
But obviously banks charge a lot of other fees.
Sure.
Or may charge a lot of other fees. And they didn't always do that.
Mm.
At the outset of credit cards, late fees. And I said, these weren't always charged.
Origination fees, prepayment fees,
Exactly. And so banks started to charge these fees. And there started to be lawsuits against it. And so the OCC put out a regulation basically being interest is XYZ. It's late fees, it's NSF fees, it's annual fees, it's membership fees, over limit fees, etc. So it's all this type of stuff. And there was a case, Smiley versus Citibank in 96, that was also unanimous, but it relied on the now deceased Chevron doctrine and basically said that the OCC validly interpreted interest.
Sure.
How it did. And so whether that, remains to be challenged under, corner post now, maybe?
Yep.
I'm not sure. I was trying to think of ways. I was so there's a 6-year statute of limitations from harm. You're not extending credit to babies.
Right.
So who's...
Yep.
But I don't know. There's very, very creative attorneys out there.
So, Okay.
So that's a good part. It's been settled. That's why this matters.
Yeah.
And that's why its import is so important now, especially because this rate exportation, because you had Cantero and you have all this stuff about what's going on with state preemption. What's preempted under the National Bank Act.
Right.
Well, one thing that's very clear is interest rate exportation is preempted.
In banking, conditions change fast. Credit teams need to adapt without sacrificing credit quality, compliance, or control. That's why banks choose Tactile's AI decision platform. It gives teams the power to design, test, and refine credit, fraud, and compliance workflows using AI quickly and securely. With seamless data integrations and built-in testing, every decision flow can be optimized in real time. With Tactile, AI isn't a black box. It's transparent, explainable, and regulator ready, so banks are always prepared for what's next. For more information, visit tactile.com. So we are going to leave the 1970s and 80s and move closer to today. And one reason why I think this is such an interesting case to talk about is both from a product and a technology perspective, right? The law is the law, the case is the case, but the things that didn't, and then all the banks moved their credit card banks to South Dakota or Delaware. But what doesn't stay stable is technology and innovation, right? So, while there is still direct mail, there's a lot more ways, I think, for financial institutions or companies. You don't have to be a bank to offer a loan, but you can reach people in different states. And, definitely from the consumer perspective, the geographic component of where is my lender or where is my credit card, these are significantly less important today. And we're just very used to a national marketplace, I feel, for especially certain types of consumer credit products. So how do you see advances in technology, innovation, product design, updates kind of interacting or leveraging or building off this decision that, like, for 2025?
Incredibly important. And this will also get back to the, dual banking system that we have. And so, because, that, as we discussed earlier, that was a moderate component of the case was, yes, mail is this, new-ish, mailing credit cards.
Mailing credit cards was crazy, but yes, that was new. Yeah. That was the new concept.
Yes. And they're like, it doesn't matter. There's nothing in this old National Bank Act that distinguishes how somebody from one state gets credit from a bank of another state. And so just because you have this new thing of mailing, that doesn't erase that distinction. And so now, as you note, my phone, I, do most of my banking on my phone. And so where the underlying creditor is of minimal importance.
Right.
I don't need to go to a branch. I don't need to do this stuff. And so you've had banks be like, okay, our tech is really not that great. We're going to partner with these entities who have better tech than us. And we're going to look to serve people. We're going to look to serve communities with lending products.
Right.
Some of the larger banks, it's not profitable for them to lend to.
Mm-hmm.
Or they don't meet this target well for whatever reason. It's too high when they lend to them.
Right.
Because they can't underwrite them well. The whole variety of reasons that fintech credit companies, partner with banks to try and feel like, here's our niche. Here's our distinguishing factor why we offer this product that Citi doesn't, that Chase doesn't, et cetera. And to do so, they are mostly going to partner with a state chartered bank.
Mm.
Claros had a really interesting stat about this from after the Colorado decision. So it was something like 71.5% of fintech and embedded finance programs offering consumer credit products partner with state chartered banks versus nationally chartered banks. And so that's a very large percentage. And so this idea of parity with 85 as upheld on Marquette, and then the corollary provision in DIDMCA allowing state chartered banks to export has been integral to this idea of using technology and having technology providers be the front end for the banks.
Right.
For the marketing, for the distribution, for all of that stuff. Where the bank remains the underlying creditor of the product.
Yeah.
The bank is the one extending the credit. The bank is the one underwriting the customer and responsible for all of that stuff from a legal perspective. And so it's that technological innovation that's it's this confidence that, hey, I am in state X.
Yeah.
And me, I live in DC. You live in Tennessee?
I live in Tennessee, yep.
Tennessee. Yeah. So you can get open a card or get a loan from Utah.
I have no idea what our state lending cap is. It matters so little in my life. I guess I hadn't even thought of myself as a consumer who could go check the price of a Tennessee loan, credit card, whatever, relative to one that comes from Utah or one that comes from South Dakota, right? That's just not actually even how I conceptualize the world. Even if it was important for me to get a product from a Tennessee institution, it's not about an interest rate level, right?
Exactly. So that's, this decision gives a lot of confidence in that.
Yeah.
But you have got, so this is where, there's a push and pull between everything.
Yeah.
And so you have got now this concept of true lender.
Yeah. Tell me about true lender.
And so this is okay, states have basically acknowledged, we can't go over it. We can't go after the bank. The bank can export that rate.
When you say the state, you mean the government or the DFI, not a state chartered bank,
exactly.
right?
Exactly.
Okay.
Government, DFI, or the plaintiff.
Sure.
In a lawsuit who's harmed. They basically the state can export that rate. What can we do? We can go after the forward-facing company for the bank and allege, actually, no, it's not the bank that's making this loan. It doesn't matter that the bank is on the name of the promissory note or the credit card agreement or whatever. That does not matter.
Sure.
What matters is that the actual true lender is the forward-facing, the company, the product-facing entity, not the underlying bank. And so, again, it goes back to kind of this idea of, again, usury. Like, we care very much about usury laws in our state.
Mm-hmm.
If we can't go after the banks, how are we going to protect our customers? What other wedge, what other avenue can we use to do this?
So
we're going to now try and go after...
Oh, I was going to say true lender. So true lender is really like who makes the loan. Is it the bank or is it the fintech partner? And if it's the bank, then we kind of can't do anything about it. But if we can argue that it's the fintech that is the true lender here, and that the bank is just providing some sort of maybe limited support, it's not, but is not actually making the loan for the purposes of like maybe this case or maybe Didmica, then we can go after them. And the case and Didmica, they only apply to banks, and you're not a bank, right?
Yep. Correct. And so, like, the argument is, we don't care what it says on the loan, on the credit card agreement. Like, we don't care that it says this is, Bank of Kiah Bank. Like, we don't care.
Yeah.
Because, the argument is like the bank's money is not actually at risk. There's a variety of mechanisms that make sure the bank, these are the allegations.
Sure.
There's a variety of mechanisms that mean that the bank is not actually there's no risk involved with the bank's undertaking of this product, a very high level. And so because it is not at risk, and it is not the forward-facing entity, no one knows who this bank is, et cetera, the actual true lender should be deemed the forward-facing entity. And so that's something that, has been an argument for quite some time.
Yeah.
States are losing that. Plaintiffs are losing that argument, though.
Okay.
It has not been incredibly successful for them recently.
And this is being decided in like the courts, but not the Supreme Court. And there's not like federal legislation that kind of provides like guidance here. This is actively like kind of being litigated?
There was.
Okay.
So, one, it is being litigated.
Okay.
The OCC put forward true lender regulations.
Okay.
But
all right.
The Biden administration, through the Congressional Review Act, overturned them.
Got it. Okay.
The FDIC determined that it did not have the authority to issue true lender regulations. So yes, it still remains an outstanding issue, even though states aren't really winning. So they're doing other things. They're trying to say, one is this Didmica opt-out.
Right.
The other is, hey, state lender or fintech, if you have got what we're going to call the predominant economic interest in the loan, meaning you buy the receivables, the forward-facing thing, you have to be licensed under our state lending law.
I mean, that actually, that kind of makes sense. You probably see that.
So you have, a handful of states, I think a few more than half a dozen or so that are pursuing this approach. Because again, it's like, we can't go after the banks here.
Right.
We've tried and we kept losing.
Yeah.
And so, but we care very much, again, it goes back to this thing, like we care so much about interest. We want to protect our customers. How are we going to do this? And so it becomes this game between the regulated entities of, okay, if you're stopping us here, what are we going to do next?
Yeah. Yeah. Almost like, what can we do with technology that allows us to get out of to go around the rigidity of state law, or not like state law, but like federal law or this case law, right? The law is the law. It's not really changing as much as the technology or the products or, I don't know, the marketing, whatever the arguments are that change. And that's kind of, it seems like why there's a little bit of a cat and mouse.
Yeah. No, 100%, because it's now, much easier than mail.
Yeah. Yeah.
To sign up for this stuff. And so you have states trying to reassert their authority.
Right.
And that's why, like I said, like they're losing in the courts in true lender so far for the most part. Not always, but, for the most part. So they're coming up with these other avenues of doing so. Which is, okay, we're going to pass legislation requiring some fintechs to be licensed under our state lending law, especially if it exceeds a certain rate of interest.
Right.
Or, this is why the Colorado case was so interesting now.
Okay. Yeah, let's talk about the Colorado case.
And so basically, Colorado, I don't know, 8 years or so ago had very big lawsuits under true lender, and they were successful.
Okay.
For the most part. They settled and everything, but as part of the settlement with these companies, the companies had to do various things in order to lend in Colorado.
Okay.
And they could adopt certain models, et cetera, with partnering and lending without getting licensed and all this jazz. They've now taken it one step further and been like, actually, we're going to opt out of Ditmica. And we're going to do so under the theory that, so again, it turns back on what located means. Yeah. And so, like I say, Ditmica has the parallel to Section 85, but it also has a new provision for opt-out. And it uses the term made, which is what all these courts have spent a lot of language just assessing what it means. So, where is a loan made? Colorado's arguing that, hey, for purposes of the opt-out, a loan is made either in the state where the lender is, or in the state where the consumer receives the product.
Sure.
And so that's what Colorado lost at the initial court level. They appealed. And the 10th Circuit agreed with Colorado and said, hey, nope, we're going to, it's like 90-page opinion. They go through and they spend a lot of time on adjectival phrases and how made and things in adjectival phrase, not a verb. And so they use that to conclude that a loan is made in Colorado for purposes of the opt-out provision. And therefore, by opting out, we are preventing states coming in or national banks coming in. Or the lender, or the lender coming in to be like, hey, I'm sorry, not national banks, state charter banks. We're preventing state charter banks from coming in and charging above the rate of interest allowed in Colorado. And in that case, I want to say there was 14 or 15 states that signed amicus curiae, supporting Colorado.
Sure.
And so with this decision and a new legislative session, just around the corner, are we going to see more states be like, hey, I live in D.C. D.C. attempted this last year. Will they try it again?
Yeah.
Will states start to say, hey, we actually want to use this as a wedge to kind of protect our consumers, because a lot of these fintechs partner with state chartered banks. Again, Park Laro, 71% of them do.
I made a note to ask you about that. You pointed that stat, and I also came across it. Why, if we're talking about Marquette and this case, but then, Ditmica comes and, levels the playing field between national banks and state chartered banks. Why do so many fintechs partner with state chartered banks?
Part of it is it's a way for state chartered banks to make money.
Okay.
Bluntly, for that perspective. Two, it's a way for them to, increase their market share, increase their range, all that type of stuff. They are the ones that more frequently can use improved tech stacks and all that type of stuff, where it's like, hey, this is a value add, for us and all that type of stuff.
Is it just that, I don't know, part of me is like, do OCC regulated banks just not do this type of partnership? Or is there is it like a Utah thing? Is there just a lot of Utah banks in our state chartered bank group?
OCC banks have typically not been receptive to bank fintech partnerships.
Okay.
Now, obviously some do.
Yeah.
And some are very successful at it. But Citi is not partnering with fintechs. And so a lot of the larger OCC banks don't do this at all. And they just, we're offering our own products and we're going to be the face. It's our brand. It's all this stuff.
Sure.
And so, there's a wide variety of reasons. Like I say, a lot of it is economics. It's, hey, and that's why, previously you saw all these enforcement orders against banks, because not all banks do this well.
Yeah. Unfortunately.
And so it's like, this is a way to money, but we don't staff appropriately. And then you get the evolved synapse debacle.
Right.
And so, this is also why you see state regulators being like, this is why we need to have better oversight of these entities. This is why we need to protect our customers against these entities.
Sure.
Et cetera. So like it very much is this push and pull between, what are state banks allowed to do? Why are they doing it?
Yeah.
And if they're harming our customers, what can we do to try and stop that? And so it's, still very much amorphous concept of how you solve for this. If I'm sure there are many of your listeners much smarter than I am on this part and thinking through ways to do this. But yes.
Well, and the other thing too is this, like, I wanted to talk to you about this Marquette decision that we didn't know that this, like I said, we didn't know this 10th Circuit decision was coming in. And you said, like, are other states going to be successful? Well, it sounds like this ruling would apply to any state within the 10th Circuit, but likely other states outside of this circuit would probably have to make similar arguments. And it's unclear if they would succeed over there. It's funny because, like, I love this, like, idea of making a loan, because, like, I don't think anyone, like, makes a loan the way you make a cake. But I guess that when I turn in my, like, financial documents and my loan application, it goes somewhere. And I like the idea that, like, it gets put into a mixer and then in the oven, and then afterwards the loan is baked, and then someone gives me that loan back and we made this loan together or something, right? Like, I love this imagery because that's just not what happens, right? Like, the question is like, what, like, the other thing is, like, increasingly like a lot of lending and credit underwriting is, like, automated. So how do you even, like, where does automation live? Like, it doesn't live in an office in South Dakota, right? It lives in, like, if anything, it lives in, like, a data center in Virginia, right? It's crazy. Like, sounds, I mean, I'm going to start spiraling, right? Like, this is crazy.
So we have Loper Bright.
Okay, yeah, you have to tell us what Loper Bright is. You have to remind us.
And so Loper Bright's basically like, hey, Chevron is dead. You don't have to listen to regulators, what they said, basically. And a lot of the FDIC interpretation of its portion of DIDMCA comes from FDIC opinion letters. Like, nothing that goes even through the APA. There's no notice and comment for this.
So much of our financial system is based on opinion letters, by the way.
It is.
That's shocking, but yeah.
It is. And so you've got FDIC opinion letters about where is a loan made for purposes of rate exportation? What ministerial actions have to be taken? And that's what we kind of spoke about a little bit in Marquette. Like, where is the loan decision made? Where are the funds exported from? And I've actually been waiting. I'm kind of surprised it hasn't happened yet. And maybe the Loper Bright decision is the thing that spurs it, like, as a challenge to these banks to be like, well, actually, you're not making the loan in your state anymore, et cetera. You're actually using this fintech.
Yeah.
And yes, you've delegated underwriting to them.
Yeah.
Et cetera. But they're not in South Dakota. They're not in Utah. To your point, they're using an AWS data center in Virginia.
Yeah.
And so I actually am a little surprised.
Yeah.
And hopefully this isn't something that now bankers or some state are going to listen to. Actually, that's a smart point, Andrew.
Honestly, though, it kind of reminds me of, there's two things this reminds me of. In, like, Flash Boys, they were talking about how all these, like, companies moved their servers to be closer to, like, the trading servers.
Yeah, because it's like that millisecond, like, or even shorter time period.
Yeah, that's what And it feels like we're going to do what happened with South Dakota and the credit card. But we're going to do that with like AWS servers, and you're going to need to buy a server in a state that has like uncapped interest rates so that you can argue like genuinely our loan is made there. Or like the fintech is going to have to come up like some state is going to have to like maybe South Dakota just needs to start appealing to a bunch of fintechs and is like, hey, I know that like maybe you want it to be incorporated in Delaware, or maybe they'll all be in Delaware, but like, you know, you need to be incorporated in a state that also has this. And, you know, the San Francisco fintech scene is going to exodus to South Dakota, right?
I mean, like that's legit been, that's I'm so glad you brought that up. That's something I've been thinking through. Like, you have these opinion letters, which, you know, the 10th Circuit in its case just basically said, whatever, they're there. They may be a little bit inconsistent, but we don't really have to give them much guidance. We don't have to really rely on them. And so these opinion letters have been the basis for like, being a lawyer, I've advised banks in the past, like, hey, what administrative functions are you doing in this state? Here's this FDIC opinion letter X.
Where do you make your loans? Like, where can we argue your work is done or made, right? When it's all kind of delivered over the internet and all of our accounts are in like electronic ledgers, right?
Exactly.
So do you, outside of like, let's say the Fifth Circuit takes this case, here's the exact same arguments, decides like in conflict with the 10th. Do you see this case going anywhere, getting any resolve? Do we see acts of Congress to kind of settle this madness and uncertainty?
I mean, my default is to say, or at least unfortunately for now, Congress is probably not going to be doing anything.
Oh yeah, we got it solved in 1980. We could do it again.
Hopefully. So like that's the kind of perfect dovetail to the conversation, which is you have this case in 1978 that's super important. And usury has been this emotional issue, an important issue since time immemorial, and states are trying to push back on it. And they just got a lot of success in this case. And you now have state chartered banks arguably being less valuable than being a nationally chartered bank. You've got an administration that is very receptive to chartering. Will you see, especially if in the next legislative session, additional states opt out?
And
they pass this law.
Just to settle it for them.
You know that you're like, okay, we already can't lend to Colorado. Can't lend to Iowa. Can't lend to Puerto Rico. Most don't anyway, but you know, you can. So say three or four more states pass. Okay, now we're looking at 10% of the states in the U.S. that are unavailable to us to lend to. This hurts our ability to grow. This hurts our functioning as a credit society. And maybe some state forgets to Colorado opts out credit cards. Maybe some state forgets to opt out credit cards. And they're like, wait a minute, now customers of this state aren't even getting credit cards. Or there's an argument they're not. Will you see some banks that are very heavily centered in state charter banks who are heavily centered in consumer lending should we consider moving to an OCC charter, because this is a fundamental component of our operations. It's a fundamental component of our balance sheet, how we operate, how we make money. And we don't want to have this uncertainty, because like you're saying, say some other state adopts it, or like say a couple states adopt it and a circuit court goes against it. Okay, that's 3 or 4 years from now. Then now you have a circuit court split, and you had a pretty persuasive, in my opinion, dissent in the Colorado case. So it's like, okay, we have a split, we have a dissent in Colorado too. This is now ripe for the Supreme Court. Maybe. The Supreme Court's also hearing fewer cases than before.
Sure.
So maybe they hear it. Maybe they're like, it's not actually quite ripe for us for this session. We're already booked up. Maybe we do it next session. So you have got this uncertainty. You've got this growing uncertainty now. Where don't you have uncertainty? You're a national bank.
National banks,
Under Section 85 in Marquette. That's well-settled law. To your point about, like, are there any open questions for this? Not really. we can now, let's just get our national chart. Obviously, there's cost, expense,
Sure.
time, and that. Like, you have to assess whether it's worth the risk and all that jazz. But if you deem it being worth the risk, you now have to settle law. And now you've had what was meant to be kind of this, parity for state and nationally chartered banks eroded.
Well, yeah.
So yeah, that's a very
those are
open
some
question in my
big
mind.
questions. I mean, it's funny again, like how quickly this like extremely settled fundamental case law for banking became deeply unsettled, how fast that moved, and to now wonder the implications of like what the future of the dual banking system, right? And the idea that as digital channels make it so much easier for different financial providers to market to potential customers outside of their state, there's almost kind of like there will be almost like digital like blocks on certain types of customers in certain areas, and everyone just kind of has to figure out is this a good system? Is this a bad system? Are people better served? Are they less served under this? And how any individual bank is supposed to react even in the face of like all the other changes, right? Just to have this area of law unsettled again.
Exactly. And then if you get 5 or so states that have opted out, and you have this fracturing of a credit market, and you have state chartered banks being disadvantaged against nationally chartered banks, will you then see Congress look to act?
Sure.
To be like, hey, this is actually not what we intended back then. Or maybe we did intend it, or who knows what we intended back then, because none of us were alive. Right. But we need to fix this. Yeah. So will that, so again, like for me, this isn't something that's going to be resolved in the next year. Like, this is a 4 or 5 year plus, if not longer, time frame. And so again, like, but if you're a bank today, and you're like, hey, we are very consumer centered loan friendly. Like, this is a core component, and we need to run the risk scenarios if 5 states opt out. And what are those things? Are they may they be a large percentage of our customers? Like, who signed this amicus curiae brief? Like, who are the states there? Who's likely to introduce legislation? Is it going to pass? Will we lose? Because obviously states have different population levels. Maybe 5 states opt out, but they account for 10, 12% of the bank's lending portfolio. Like, that's a huge hit to potentially take. So,
well, these are some big questions, and I don't think we'll get the answers today, but at least we've got a good lay of the land. And if we see another circuit decide on this case, or if we see further opt-outs or, big, state national charter conversions, I will definitely have you back on to talk about, the fallout from these 2 cases, arguably.
That sounds great.
Well, thank you, Andrew, so much for joining me.
Yeah, this was wonderful. No, like I said, I've been a huge fan of all your podcasts, and this is so exciting to be on it.
All right. Well, have a great rest of your day.